trial. The trial. People say, I want my day in court. That's your day in court. Your day in court is the trial. It's not so much like Perry Mason, though, and there's a lot of sitting around and waiting. Let's start with jury selection. Jury selection, it seems like it's nothing at trial, but it might be the most important part of the whole process. A better name for jury selection probably should be jury deselection, because the goal of the attorneys in jury selection is to identify those jurors who will not be favorable to that particular attorney's case and make sure they don't get on the jury. There's two types of jurors you want to be looking for. Those jurors who really feel strongly against your case, well, those are people you want off there. And there's those jurors who are clear leaders, and you don't know what their position is on the case. If they're a leader and you don't know what their position is, they're dangerous. You want to make sure that they're off the case if possible. Now, once the jury is set, the parties gets to give their opening statements. The plaintiff goes first, and then defense goes, and then the plaintiff gets a second try, and that's the rebuttal to what the defendant says in opening statements. And the opening statements is essentially what both sides feel the evidence is going to show. Now then, the parties present their cases in chief. The plaintiff goes first. The reason why the plaintiff goes first, because the plaintiff has the burden of proof. If the plaintiff doesn't prove anything, the defendant wins his case. So plaintiff has that opportunity to go first and present all his witnesses or her witnesses. You can present the witnesses in any order you want. The idea is to present it in an order that's going to be most persuasive to your case. And on the plaintiff side, and on the defense side too, there's generally two types of witnesses. Your expert witnesses, those are people who have expertise on the issues, some certain issues that are important in the case. In a plaintiff personal injury case or a plaintiff personal injury case, you're usually going to have doctors who are experts. You might have engineers testifying in the form of accident reconstructionists. You might have psychologists to testify. Any kind of expert that talks about the plaintiff's injuries is an expert in the plaintiff's case. And the expert can be a treating doctor, or it can be somebody that the plaintiff hires. Now, there's also those people who testify as to how this impacted the plaintiff's life. And some of those witnesses are going to be the plaintiff's family, co-workers, friends, really the people who know what the plaintiff's life was before the accident and how it is now, with special attention to those activities of daily living that are impacted by the accident. So you want to get a good before and after with real life people who know the plaintiff. Now, after the plaintiff puts his case on, the defense that's usually when you feel the best, after the plaintiff puts their case on, because here comes the train. The defense is going to try to poke holes in all parts of the plaintiff's case by putting on the same types of experts and the same types of lay witnesses, maybe witnesses who have a different viewpoint than the lay witnesses that you put on. And they might have expert doctors who either examine the plaintiff or only reviewed the medical records. Well, finally, then all the evidence is going to be in, and it's going to come time for the jury to decide the case. Plaintiff puts on his closing argument, which summarizes all the evidence in a way that's favorable to the plaintiff. Defense put on his closing argument, and the plaintiff gets to come back one more time to rebut the defense's closing argument. That's when the jury goes out to deliberate, and how long the jury's out to deliberate, nobody ever knows. It can be minutes, hours, or even days. Generally, you look for them ordering pizza, and then you know they're going to be out for a while. And the judge's staff has to leave by 5 o'clock, so if they're not done by then they can stay, they can go, but that's a key, that's breaking point is when the judge's staff has to leave around 5 o'clock. The attorneys have their cell phones, so the judge can call them when a verdict comes out, and the attorney will call his client and let him know what the verdict was. There's an old saying, it's not over till the fat lady sings, but sometimes it's not even over then, because there can be mistakes at trial. And we'll talk about that in the next piece, the appeal. I'm Richard Risk.